Hello, and welcome to Williams Mullen's Trending Now, an IP podcast, a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets such as patents, trademarks, copyrights, and trade secrets. I'm your host, Janet Cho, and today I'll be joined by my colleague, Ed White, a partner in our intellectual property practice group here at Williams Mullen, and we'll be discussing the Digital Millennium Copyright Act, or the DMCA, and its benefits to copyright owners and online service providers. And just for ease of reference, I will be referring to online service providers as OSPs. So before we get started, I wanted to say hello to my colleague, Ed. How are you doing today?
I'm doing well. Thanks, Janet.
Good. Well, I think we should just, dive right into it because this is a really important and I think timely topic. I think the best way to get started is if maybe you can tell us a little bit about the DMCA and, what was the genesis of it?
Sure, absolutely. It's funny too, because I think right now we're having a little bit of a discussion in the country over these early internet-related pieces of legislation, whether or not they need to be updated, et cetera. Certainly the DMCA one that is a piece of legislation that I think has stood the test of time fairly well. The genesis was essentially because at the time, the act passed in 1998, OSPs were coming online and they were concerned that by virtue of sharing information, in many cases information that was posted by users, that they would be open to liability claims, intellectual property liability, specifically copyright liability claims or contributory copyright liability claims. So that was the concern of the OSP. Likewise, copyright owners, while excited that their content would have perhaps a wider audience through the internet, they also became concerned that that wider audience could lead to wider potential copyright infringement. And so the DMCA tried to strike a balance to provide the OSP some protection, and we're going to talk about that in a bit with safe harbors, while giving copyright owners an easy mechanism to have infringing content taken down. So that's the genesis in a nutshell.
Well, that's really helpful, Ed. And I know that with laws like this, especially ones that have been around for a long time and are fairly complicated, there is some mythology and there are some, popular or memorable topics. And I think you mentioned safe harbor, which I think it sounds like a very all-encompassing and maybe even provocative phrase. So what exactly is the safe harbor provision in the DMCA and how might it benefit, if at all, copyright owners and OSPs?
Sure. Well, from a general standpoint, a safe harbor is just as it sounds. If an OSP does the right thing when they get a complaint from a copyright owner in removing that content in an expeditious manner, then they can protect themselves, essentially take advantage of a safe harbor from contributory liability claims. And so that's what a safe harbor is generally. There's actually really four types of safe harbors that cover OSPs. The first type is an OSP that hosts or stores and may, in that capacity, make infringing material available. And that content is typically stored by the OSP at the direction of users. Then there's the transmission one. Basically information that's transmitted or routed or provided through a connection by the OSP through a digital online source. And if there's infringing material that goes along that digital online connection, OSPs can be protected in that case. The third is where an OSP is in the business really of caching material. And if they happen to cache infringing material on a system or network and the information was initially made available by somebody else, well, once again, the OSP who's in the caching business can take advantage of a safe harbor. And then the final one is that OSP that provides links or refers users to online locations. And if those locations contain infringing matter or activity, once again, that OSP that's in the business of essentially referring users to other locations can avail itself of the safe harbor.
Well, I think the safe harbors are a really, really interesting topic. And it sounds like for many copyright owners and OSPs, this is something that they might want to learn more about. But as with every law, it's probably not as straightforward as it sounds. So I'm assuming there's something you have to do to either qualify to take advantage of the safe harbor or fall? There's something you have to do, or there's a status you have to evince in order to take advantage of the safe harbor. So are there any prerequisites in order to take advantage of the safe harbors?
There are. And so, again, while this is a great tool for a copyright owner, as far as expeditiously getting content taken down, likewise, as we discussed, it's a great opportunity to avoid liability for an OSP. But an OSP has to do the right things to avail itself of the DMCA safe harbor provision. And there's a few items right out of the gate that they have to get right. The first is that they have to designate an agent for the service of copyright claims. Typically, that's done on their website, but it's also done, and this is an important part, by filing with the U.S. Copyright Office the name or designation of their agent for those complaints. They also have to adopt and post on their website a repeat infringer policy. Essentially, those users who come to that website over and over again, who infringe copyrighted content over and over again, that policy should let them know what will happen to them should they do that, which is typically a termination of their services. They also need to make sure that when they do get a complaint, essentially a takedown notice from a copyright owner, that they're managing that process well and efficiently. That they're expeditiously removing the content, that they're making sure that if there is a counter notice, that's managed properly, et cetera. And we'll talk a little bit about counter notices and more of the specifics of the process in a bit. And as I said earlier, they need to reasonably implement that repeat infringer policy as well. So they're managing the takedown process and they're managing that infringer policy. Those are the steps that an OSP needs to take to avail itself of the DMCA safe harbor provision.
And that's very helpful, although it also sounds very daunting. If I'm an OSP and this is really my first foray into all of this, and I'm just basically dipping my toe into all of this, how would you recommend that I go about designating or acquiring an agent at the U.S. Copyright Office for the purpose of receiving copyright complaints? Because that's definitely something I would want an agent to handle, since I, as an OSP operator, may not necessarily know what to do with that kind of information.
Yeah, and it's interesting you should ask that, Janet, because that's, in my mind, one of the trickiest parts here is that people oftentimes will implement on their website, and OSP will implement a very good takedown regime, and they'll make sure that it's being implemented well, but they forget about designating that agent. And if you don't designate the agent properly, you really can't avail yourself of the safe harbor, even if you've done everything else correctly. So let's talk a little bit about that. When you're designating an agent, that agent can be a human being. It can be a department within your organization. It can even be a third party, like an outside counsel. So any one of those, agents can be designated to receive those complaints. And once you have designated your agent, you need to provide that contact information really in two places. One, on the OSP's website, and two, at the Copyright Office. And how you go about doing that at the Copyright Office, it's actually fairly easy. You go to copyright.gov. There is a DMCA pull down there where you can go in and fill out an online form to designate your agent in the case of DMCA complaints. So that part is actually fairly easy. The toughest part is just reminding OSPs that they need to take that step.
And that's really helpful, Ed. I mean, I think one thing that, and you mentioned this in your prior comment, in addition to the agent, the designation of the agent, it sounds like it might be helpful for an OSP to maybe discuss or elaborate what it does in response to DMCA issues or complaints. I think privacy policies on websites at this point are pretty ubiquitous, and everyone knows where to go to look for that, and everyone knows that a website likely has such a policy. Do you think that on top of that, an OSP should elaborate or post its DMCA policy on its website as well?
Absolutely, Janet. It should. And sometimes you'll see on a website where there's a DMCA link that brings someone to the DMCA policy, and there they can find what that OSP is requiring for, let's say, a compliant takedown notice. Other things that might talk about is sort of how it will work with the copyright owner with regard to counter notices from the user. But basically alluding to the things that the OSP is willing to do and will do to be compliant with the DMCA is important to have in that policy. And of course, there's the repeat infringer policy aspect of that as well that needs to be listed there. That's once again one of the things where people tend to fall down, in addition to not having that agent designated at the Copyright Office, is not including that repeat infringer policy on their website. Do you want me to talk a little bit about what should go in that?
I think that would be helpful just to give some highlights.
Sure. Yeah, because they can be fairly easy. They don't have to be very complicated. Essentially you're adopting a written repeat infringer policy. You're posting that on your website, and you're notifying the users of your website or your OSP services that should they infringe copyright, that it's against your copyright policy. And if necessary, when you see that someone is inappropriately posting content, certainly more than once, thus the repeat, then you're going to, either charge them with infringement or assist in an infringement charge being brought against them. But most certainly, you're going to terminate their ability to use your OSP services. And that's really the key. There's no magic script for a repeat policy, but those are the things that you need to get in there. It does need to be written, and it does need to be up on your website.
Thanks, Ed. I think you've provided a lot of useful information about DMCA and safe harbors and what the benefits might be to OSPs and content owners. And I hope that for our listeners, this has been a really helpful starting point in terms of understanding this content and maybe being better informed about protecting yourself and your presence out there in the internet. So thank you so much, Ed. I really, really appreciate your time. And for our listeners, we actually plan on producing a second part to this podcast as it relates to DMCA takedowns, which I think is another concept that many of our listeners are likely to be familiar with, and the safe harbor regime and practice. So please be on the lookout for it soon. And that'll wrap up our discussion on DMCA and benefits to content owners and OSPs. I'd like to thank Ed White for joining me on Trending Now, an IP podcast. If you have any questions or suggestions for future episodes, please contact us. You can also visit our intellectual property practice page at williamsmullen.com/IP. There you can find out more about our team, as well as past episodes of this podcast and legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thank you so much for listening, and until next time.